Good afternoon, everyone. My name is Daniela Caruso, and I am the director of the Center for the Study of Europe at the Pardee School of Global Studies of Boston University. It is my great pleasure today to introduce Dr. Professor Solanke to give a talk today on a topic that is of great interest to us, in particular to our course in EU law. Some of our students are here. A brief introduction to somebody who would deserve a much longer introduction. Dr. Solanke, who received her PhD in law from the London School of Economics, is professor of EU law and social justice at the School of Law of the University of Leeds. Her research and teaching focus on EU law, discrimination law, race and law, and alternative dispute resolution. Her research is socio-legal, historical, and comparative. Professor Solanke has held an impressive range of visiting professorships, including at the Harvard School of Public Health, at the University of Cambridge, and at the European University Institute. In addition to numerous articles in peer-reviewed journals, her publications include a textbook on EU law and 2 monographs, Making Anti-Racial Discrimination Law and Discrimination As Stigma, a theory of anti-discrimination law, published by Hart in 2017. It is an honor to have her speak with us today. I thank everybody for being here. The attendees are very welcome to write up questions in the Q&A box, and I'll moderate the Q&A session after Professor Solanke's presentation. Thank you for being here. Thanks, Elizabeth, for allowing us to be here. And Professor Solanke, please.
Well, thank you very much, and thank you to you for the invitation to come and talk to your students. I'm really looking forward to this. I used to come and teach in the United States at Wake Forest University, so I have taught European Union law to American students, and I always enjoy it because even though the European Union isn't as familiar to you all, you seem to be more aware of the kind of constitutional issues and the constitutional principles, which is quite different to the students in the United Kingdom, who have a more practical familiarity with the European Union, but are less familiar with the kinds of principles that underpin European integration. So I'm really looking forward to your questions after my talk today on Brexit, citizenship, and human rights. So I have some slides, so I'm going to share my screen. Let's see if I can find the slides. Here they are. So can everybody see those slides? Yes, great. So as I said, the topic is Brexit, citizenship and human rights. And what I'm really going to focus on in this talk is a specific cohort of citizens called the Zambrano families. And some of you may have already heard of the Zambrano families. I'm sure you've come across the Zambrano case. And the way in which the Zambrano families have been treated in the United Kingdom is perhaps very different to the way in which they've been treated across the rest of the European Union. And not only Brexit, but also COVID, the COVID pandemic has had quite specific implications and consequences for this group of people. So here's an overview of my talk. I'll just say something briefly about intersectional discrimination, which is the approach that I'm taking to given in this talk today. And then I'll say a little bit about Brexit and the hostile environment, which was it was kind of like a policy towards immigration in the United Kingdom that predated Brexit and, if you like, rumbled on underneath Brexit. And there are authors who describe Brexit as just another manifestation of the hostile environment. So I'll say a little bit about the hostile environment, and then I'll explain the Zambrano case and the way in which European Union law was used to give rights to non-European migrants in the European Union. And then I'll switch to looking at the British response to the Zambrano ruling, the legislative response, and then the judicial response. And then I'll talk a bit about Brexit and the European Union settlement scheme, and I'll say a few words about COVID. So to begin with then, the concept of intersectional discrimination. as you may know, was introduced by Kimberly Crenshaw in 1989. And the purpose of this concept is to encourage us to adopt a synergistic approach to discrimination, so that we're not just looking at race or gender or disability, but in the paradigm, we're looking at race and gender together. So an intersectional approach insists that anti-discrimination law recognize that inequality occurs in a synergistic manner, rather than in neat categories that can be separated from each other. So I'm using the concept of intersectional discrimination to highlight the precarious position of Black and migrant women during Brexit, and the erosion of not only their rights, but those of their citizen children. Throughout the Brexit countdowns between 2016 and 2020, if you remember, there were a number of Brexit days which kept being postponed. So we had at least 4, I think, Brexit exit days in total. Attention during that time in government and in civil society was paid only to the impact of Brexit on adult European Union citizens in the UK and adult United Kingdom citizens in the EU. The value of an intersectional approach to citizenship highlights, however, another group enjoying citizenship rights under EU law: non-migrant European Union infant citizens whose parents are non-European Union nationals. So these are also described as third country nationals in EU parlance. And these are predominantly Black women from Africa, Asia, and the Caribbean, who are parents to Black British citizens. Now, these non-EU nationals who are parents to Black European Union, or in the case of the UK, Black British citizens, were given rights under the Zambrano case of 2009, where the Court of Justice established European Union citizenship rights for non-migrant member state nationals, and also the right to residence for non-EU nationals in order to care for these non-migrant children holding European Union citizenship. Now, it was always clear that these residency rights given in EU law to the non-EU parents of these British citizens would automatically disappear at the end of the Brexit transition period on the 31st of December 2020. Yet, as I said, the interests of these children and their mothers was not considered in the run-up to Brexit. The situation of these families was ignored by politicians, the mainstream media, and the mainstream campaigns. As the Zambrano infants are United Kingdom citizens residing in the United Kingdom, and therefore not migrant EU citizens, they don't fall under the Citizenship Directive. So their status wasn't discussed during Brexit negotiations or during ratification by the European Parliament, and Zambrano families were not mentioned in the withdrawal agreement. So the importance of EU law for these infant EU citizens and their non-EU parents was overlooked. It was only late in 2019 that these non-EU parents were given the possibility to apply for residency rights through the European Union Settlement Scheme. There are many concerns about how these applications are processed and reviewed in the Home Office. And another concern is how these families, who, as I will explain, do not have access to public funding, are surviving the COVID pandemic. So as a backdrop to Brexit, so as I mentioned, the backdrop to Brexit is something called the hostile environment. This hostile environment predated the European Union referendum, and so also predates Brexit. So the erosion of protection for these infant Black British citizens began actually a long time before the referendum and Brexit, because they developed under the hostile environment policy, which was introduced already in 2010 by Theresa May while she was the Home Secretary under the Conservative Liberal Democrat coalition government. The stated aim of the hostile environment policy was to force the departure of migrants who were in the United Kingdom without permission to remain. The whole idea was to make life in the country unbearable for them by making changes to immigration law that restricted their access to housing, their access to bank accounts, and even driving licenses. However, in addition to this, the Home Office mounted a number of high-profile campaigns, such as the Operation Varken, which was where vans drove around parts of London where there was a high population of migrant families, telling them that they should go home or face arrest. Now, that kind of campaign was cancelled because there was a high-level public outcry and there was a threat of legal action. But nonetheless, the hostile environment continued throughout Brexit and continues to this day. You may have heard about the Windrush scandal, which is another more recent manifestation of this policy of creating a hostile environment. In particular, in relation to European Union law, the hostile environment evolved with legal reforms such as the Zambrano Amendments. As I will explain, these amendments were introduced to limit the impact of the Zambrano decision and deepen the hostile environment to immigrants in the UK. So, where the Zambrano decision created a right to remain in European Union law for third country nationals, so non-EU nationals, the Zambrano Amendments in national immigration law removed access to welfare, which would enable them to reside in the United Kingdom. So now I'll explain the Zambrano case, and then I'll talk about the Zambrano Amendments. So the Zambrano case was a case sent to the Court of Justice from Belgium. What happened in Belgium was that there was a Colombian couple who had arrived in Belgium and sought political asylum there. So they were asylum seekers and they had fled Colombia due to political persecution. Now, they had been refused asylum, but they hadn't been removed from Belgium because of a national policy preventing the removal or the return to a country where individuals face political persecution. So the Zambrano family were allowed to remain in Belgium. While they remained in Belgium, they not only worked, but they also had 2 children. And as they were working, they were able to support these 2 children. The problem arose when Mr. Zambrano lost his job and tried to apply for some kind of unemployment benefit. That's when the authorities decided that he had no right to remain in the country, even though he had been there and he had been working, he had been paying taxes, so he had been contributing to society and to welfare. So he challenged the decision to deport him, and a question was sent to the European Union Court of Justice, asking whether they could be removed. And the basis of their argument to stay in Belgium was that their children were actually European Union citizens. And if the parents had to leave the European Union and return to Colombia, then of course they would have to take their children with them. And if their children had to leave the European Union, they would be deprived of enjoyment of their rights as European Union citizens. So this was a case that is seen as seminal because it's a bit of a departure from the usual case where you have a parent trying to derive rights from their children who are citizens of the Union. Because in the Zambrano case, the children hadn't left Belgium. So they were citizens of Belgium trying to rely upon European Union citizen rights in Belgium. Now, the Court of Justice first of all, I suppose it was lucky for them that the Advocate General who dealt with this case was Eleanor Sharpston. And in this case, she used this case to develop an approach to European citizenship that she had already presented in an earlier case. I think it was the case of Metok, where she had started to argue if European Union citizenship rights are to have any substance, then those who hold them should be able to enjoy them in their own member state as well as a host member state. So they shouldn't be just migrant rights, just as the rights in Article 45 are migrants' rights. But if they are truly citizenship rights, then they should be capable of being enjoyed in the home member state as well as a host member state. So she developed this line in the Zambrano case, and the Court of Justice did in fact adopt her line of thinking. So the Court of Justice said in its decision in the Zambrano case that in the circumstances of a family such as the Zambrano family, Article 20 would preclude a member state from removing an individual. So Article 20 precludes national measures which would ultimately have the effect of depriving citizens of the Union the genuine enjoyment of the substance of rights conferred by virtue of their status as citizens of the Union. A refusal to grant a right of residence to a third country national with dependent minor children in the member state where those children are nationals and reside, and also a refusal to grant such a person a work permit has such an effect. So in essence, what the Court of Justice did in this Zambrano case was provide in European Union law a right of residency for non-EU nationals or third country nationals who were carers for or parents of children with European Union citizenship. So even if these third country nationals did not have a right to reside under national law, if they were looking after children or even adults who happened to have European Union citizenship, they could claim a right to reside. So the European Court of Justice opened up a new flank in citizenship law by creating this right to reside in European Union law, separate to national law. Now, in relation to the United Kingdom, some of the official data on those who eventually claimed this right to reside, the Zambrano right to reside, the data showed that 50% of the mothers and carers who gained these residency rights were of Nigerian, Jamaican, or Ghanaian nationality. 94% were lone parents, and 79% were women. So the key beneficiaries of these Zambrano rights were Black women from either the Caribbean or Africa. Not solely. There are, of course, non-EU nationals from other parts of the world who gained a right to remain using the Zambrano doctrine. But predominantly, you can see from this data in the UK, the majority were women from Africa and the Caribbean. So you can imagine, in the context of this hostile environment, the British government were quite furious when they realised that the European Court of Justice had more or less gone above their heads and created this independent right to reside in the United Kingdom in European Union law. So then it set about to dissuade those who could claim a right to remain using the Zambrano case from doing so. And the way in which it did so was to introduce some amendments which meant that anybody claiming a right to reside on the Zambrano case would lose access to a number of key benefits. So there were 3 regulations that were introduced, And these were called collectively the Zambrano Amendments. And what they did was ban those with a Zambrano right to reside from key housing and welfare benefits, including income support, job seekers allowance, employment allowance, pension credit, housing benefit, council tax benefit, child benefit, and child tax credit. So these are very basic key welfare provisions that those who are in work and those who are out of work normally have access to. And actually, other migrant families who are in the United Kingdom not using the Zambrano right still have access to these. So these amendments were adopted specifically to target the Zambrano families. And essentially what that did was transform this hostile environment for immigrants into a hostile environment for these British citizens. Because of course, if their parents no longer have access to basic welfare rights that all other citizens have access to, these children, predominantly Black British citizens, are being treated differently to their peers simply because of the nationality of their parents. So they lose access to very basic things such as free school meals, free school uniforms, and travel passes. And they lose these rights regardless of whether their parents actually work or not. They simply lose these rights because of the way in which their parents have gained a right to residence. So these children, as I said, simply become victims, if you like, of the attempt by the government to create a hostile environment for migrants. So as you can imagine, these Zambrano amendments were challenged in the courts and culminated in a case in the Supreme Court just in 2017, I believe that was. However, the judges felt that they didn't have any basis to go against, to rule that the Zambrano amendments were unlawful. And in the Harrison case, this first case here, I copied out this this passage for you because this became the general approach taken by the judiciary when presented with these questions about whether the Zambrano amendments were lawful. So in the Harrison case, the Court of Justice, the Court of Appeal said that the right of residence is a right to reside in the territory of the EU. It is not a right to any particular quality of life or to any particular standard of living. Accordingly, there is no impediment to exercising the right to reside if residence remain possible as a matter of substance, albeit that the quality of life is diminished. So what has ultimately happened to these Zambrano families is that they are forced to rely for housing or for financial support on local authority funding given under emergency powers to protect children, essentially. So the Sane case continued this line. In the Sane case, essentially the court said that, and this is of course another British court, the court said that because Miss Sane was very resourceful and demonstrated specific skill in dealing with her destitute condition, there was no realistic possibility of her leaving the United Kingdom. So because she had managed to stay in the United Kingdom, the court felt that she didn't actually fall within the danger of being compelled to leave the European Union. In the case of HC, where a woman had to leave the marital home because of domestic violence, the court there again said that she has her right of residence, but this right of residence doesn't guarantee her any quality of life. So even if she's destitute, that doesn't compel her to leave the United Kingdom or the territory of the European Union, and therefore her child can still benefit from genuine enjoyment of her European Union citizenship. And in that case, it was interesting because that's one of the first cases where the question about the best interests of the child was raised, because that's a very common idea when a common concept when dealing with family law cases where there are children involved. You know, the judges, and this is a concept in international law, the judges will think about what are the best interests of the child in this situation. Well, in relation to the Zambrano carers, this was held by the judges in the United Kingdom not to be a paramount concern. So in a case called Hines, the judge said that the reviewer at the local authority level was not obliged to consider the best interests of the child, whose name was Brandon, as paramount. These can be taken into account, but they do not have to be decisive of of the decision taken. So even this well-established concept of the best interest of the child was not strong enough to protect the Zambrano, or to protect families residing on the basis of the Zambrano case from destitution. So the legislative response, the Zambrano Amendments, remain in place. And as I said, a case did go to the Supreme Court, but the Zambrano Amendments were upheld. The only dissent was put forward by the then president of the United Kingdom Supreme Court, Lady Hale, and the reference there is wrong. It should be UKSC 73, not 17. And she said, you know, I find this a very troubling case because it's not a case about adults' rights, it's a case about children's rights, specifically the right of two very young British children to remain living in their own country and to have the support which they need in order to enable them to do so. Self-evidently, they need the support of their mother in the shape of the care which she is able to give them, but they also need support in the shape of a place to live and enough to live on. And then she goes on to say that there is a distinction between Zambrano carers and other non-EU citizens. Zambrano carers are not like other third country nationals because they have British or other EU citizen children dependent upon them. So whereas the judges in previous cases have focused very much on the status of the parent, Lady Hale was trying here to shift that focus onto the child, and in particular to raise the prominence, the fact that these children are British children, and that they should have the right to enjoy the same benefits as other British children growing up in the country of their birth. But nonetheless, she also agreed with the decision that the Zambrano Amendments were lawful. So as we moved into Brexit, the Zambrano families didn't have access to public recourse. And as I said at the beginning, as we moved through the Brexit process, the Zambrano families were not at all at the forefront of anybody's attention. So when we got to Brexit, it was really only after the withdrawal agreement had been agreed that these Zambrano families were given any way to apply for an alternative residency right. Because obviously, as I said, once the United Kingdom left the European Union law is no longer valid in the United Kingdom. So these Zambrano carers and parents whose right to residence relies on European Union law would lose any right to reside. So in June 2019, the government finally extended access to the European Union settlement scheme to the Zambrano carers. So they also have to apply for settled status, and they also have to be able to prove that they have been resident for a full 5 years in order to successfully gain that status. Now, the important thing is that this status can only be applied for until the 30th of June 2021. So there isn't very much longer left for these families to apply. And the data at present suggests that many families who are eligible to apply haven't yet applied. So these are applications that are based on a derived right, and I pulled out some figures from the government website to share with you. In total, there were just over 4,390 applications received from individuals trying to claim a right of residency based on a derived right. So as in the Zambrano case, where the parents will derive a right from the children. And there are different routes of derived rights. So there's the Singh route, there's the Chen route, and there's the Ibrahim and Texera route. But I've put in bold here the applications coming through the Zambrano route. So 3,660 applications were received from Zambrano applicants, and just over 2,500 were concluded. And you can see that that is the second largest category of applicants from those based on a derived right. Now, the total refusals of all of these derived right applicants is 1,760. That last figure is the frightening one, because 94% of those refusals are based upon those who are Zambrano applicants. So they're based, the 94% of those who apply for a settled status because they are looking after a British child, 94% of those applicants have been refused. So that's quite a scary figure. It isn't surprising to many who are familiar with the Zambrano situation, because clearly the government introduced the amendments because it didn't want to encourage Zambrano families to reside in the United Kingdom, and now it's using the EU settlements, the settled scheme, to remove that right of residence for these families. So it's a very worrying situation for, as I said, these Black British children. Another interesting thing that was raised by Lady Hale in her kind of dissent or in her comment to the HC case, was the question of how these children would be looked after if the parent supporting them was unable to work, whether because of demands of childcare or for any other good reason. Well, one good reason arose last year in the shape of the COVID pandemic, when many people found themselves unable to work, and many of those who were unable to work were also not able to be furloughed. Now, the Fawcett Society conducted a survey last year of Black and minority ethnic women to find out how they are coping. And one piece of data that they presented in their conclusions was that nearly 25% of Black mothers struggle to feed their children, compared to just 19% of white mothers. Now, I expect that the majority of those they spoke to were citizens. And so my question is, well, what then is the situation for the Zambrano mothers who have no recourse to basic welfare? How on earth are they managing if they have lost their jobs and they have lost informal support, so maybe informal childcare? How on earth will they be coping during the COVID pandemic? So to summarise, I think that Brexit has been used by the government to fulfil its aim to deprive the Zambrano carers of their right to residence in the United Kingdom. In doing so, the government has jeopardised the citizenship rights of Black British infant citizens. And I think that the European Union should have been paid more attention to this during the whole Brexit period, because actually this is a breach of a right set out in the Charter of Fundamental Rights. So Article 24 of the Charter says that children shall have the right to protection and care as is necessary for their well-being. They may express their views freely, and such views should be taken into such matters which concern them. And then in all actions related to children, whether taken by public authorities or private institutions, the child's best interest must be a primary consideration. And then the third paragraph, every child shall have the right to maintain on a regular basis a personal relationship and direct contact with both his or her parents, unless contrary to his or her interests. Well, it seems to me that those rights were just not taken seriously during Brexit. In particular, the European Commission should have been more cognizant of the Zambrano carers and of the rights of Zambrano families during the Brexit procedure. And it seems to me that if the EU does want to become the protector of human rights that it desires to be, then the European Union institutions, perhaps in particular the Commission, but also the European Parliament, will have to do much better. Thank you.
Thank you so much, Professor Solanke. This was great, eye-opening, and very thought-provoking for me. I have a number of questions, but I really would like to let my students speak first. Some of them have especially interest in the United Kingdom, in the treatment of minorities in the United Kingdom and elsewhere in Europe. So, guys, let's respond to this. Anyone?
Hi.
I had a big question. Has any claim been brought to the European Court of Human Rights for indirect discrimination?
Yeah, that's a very good question. It hasn't been. And this again was something that Lady Hale mentioned in the HC case. So she did say there might be grounds for not just indirect but direct discrimination on the basis of nationality for the Zambrano families. But I think everybody is so weary because of Brexit, and now of course it isn't relevant because we're not part of the European Union anymore. So it would be kind of futile. Exactly, it would be futile to bring a case based on the lack of access to the Zambrano rights.
I'm going to ask a question myself, a small one, and there are larger ones. But I wanted to ask you, so in the United Kingdom now, what kind of avenue for recourse what might there be? So one thing you mentioned is the fact that there's some time, a little window of time until the end of June to apply for through the settlement scheme for those who have enjoyed Zambrano status for the past 5 years. Has there been activism on the ground to make sure that those who can apply will apply? Have there been any appeals against the denials? Is there activism on the ground that would allow some movement there?
So
sorry.
Sorry, go ahead. Should I answer that one first?
Please.
So there is activism on the ground, but it's very difficult to challenge the refusals because the procedure isn't very transparent. And it's also very difficult to encourage an appeal because these are families who really do not have very many resources. So they don't have resources for solicitors or for lawyers. And there are organizations which are obviously set up to support migrants and asylum seekers, etc. But their resources are quite limited. And to bring such a case to court, you do need at least a minimal amount of resources. So it's very difficult to mount a legal challenge against the refusals. And it's not just the Zambrano families who are being refused. Many people who should have a right, because they fulfill the criteria, are not being granted settled status. It's very problematic.
And continuing on the look within the UK legal system, you mentioned two possibilities, two sort of legal hooks, so to speak. One internal, which basically boils down to the best interest of the child, and one external, which is the UN Convention on the Rights of the Child. And so I was wondering whether you see any possibility of judicial redress through these two instruments, one very local and one international.
So interestingly, the reason why the government extended the European Union settlement scheme to the Zambrano, to the derived rights group, was precisely because of its responsibilities in international law. So it was highlighted that the government was not respecting its obligations under international law by preventing the Zambrano families and the Chen families and the Singh families from access to the European Union settlement scheme. So as far as the government is concerned, it has fulfilled its duty by enabling access. But enabling access doesn't mean granting residency. So I think there would be a ground to bring a case there under international law. But again, I mean, these would be very long challenges. And by the time we get to the end of it, you know, the families may already have had to leave.
Any other question, guys?
I mean, it might be worth thinking more about how the convention could be used, even though we are no longer part of the European Union. But that would be quite a. I'm not sure what provision in the convention. Maybe the Article 8, the right to private life, the right to family life, could be used before the European Court in Strasbourg to protect these families. But again, that would need to first of all go through the domestic system, and again, that would take a long time.
But that's that was Caitlin's idea, right? To try and use that angle, which I think
exactly.
remains lively. Now, vis-a-vis the European Union, the point that you make is powerful, which is, you know, there is usually a process of scrutiny of the legality of agreements that the European Union enters. When there was the draft agreement of accession to the European to the European Convention of Human Rights, that agreement was taken apart by the European Court of Justice, while the UK-EU Brexit agreement was stipulated without that kind of scrutiny. And as you say, something so important went observed, to say the least. Why? In other words, again, so what we're trying to understand here is the level of activism around the issues of discrimination in the United Kingdom and in the European Union. This is part of our general interest in observing these kinds of dynamics. Yeah. How is it possible that no such challenge was brought, even though in the United Kingdom, the Zambrano case had received so much attention, and the Zambrano Amendments had no ambiguity about their purpose?
Exactly. Mm-hmm. So I think the issue is what I mentioned at the beginning, that they just fell under the radar. Immediately, the attention was on UK citizens in the European Union and European Union citizens in the United Kingdom, because those were the constituencies that were vocal, that had political representation, and that had social capital and economic resources to make their voices heard, whereas these Zambrano families didn't. So they slipped under the radar. And there were cases brought, or there was an attempt to bring cases in relation to, you know, the deprivation of European Union citizenship rights, but they didn't go very far. The cases that did make it, of course, were the Miller case and the White case about whether Article 50 can be revoked once triggered. So those cases did make it before the highest courts. But there was just never any attention paid to the Zambrano families. The focus on the rights of Europeans, whether they were United Kingdom nationals or members of the other member states, nationals of the other member states in the United Kingdom, was so complete that there was just no place for any other constituency to be mentioned. And also, you know, understanding the intricacies of the Zambrano situation is quite complex. So you've got to really understand the difference between EU law and UK law. You've got to understand the difference between European Union citizenship and its link to national citizenship. You've got to understand the position of third country nationals under EU law and under national law. You've got to understand all of that before you really get to grips with the idea of why there are British citizens whose parents are non-EU nationals but have a right to reside under EU law. So it wasn't really an easy campaign to start or to get a large movement around. You really had to be either working in the field of immigration or working in the area of those families with no recourse to public funding, or working in European Union law and migration, or working as I do in discrimination and European Union law, in order to recognize the problem with this cohort. And I think that by the time that we got to the withdrawal agreement, the appetite and the stamina for taking cases before the European Union had just dissipated. And the idea of challenging the withdrawal agreement before the Court of Justice was just not on anybody's agenda. Even the European Parliament could have done it. But even the European Parliament, by that stage, there was such exhaustion and there was such a desire to move on to other things that I think everybody just wanted to get Brexit over and done with and then deal with the fallout. And these Zambrano families are definitely a casualty of that fatigue, Brexit fatigue.
And I have a question from the audience that I would like to bring. This is from Julian Ospina. Has there been any major improvement since the Zambrano instances? I guess it's referred to the Zambrano Amendments, or so improvements or setbacks in your opinion? I think this is about the trend. Where are we going with this? If you would like to address this.
So the Zambrano Amendments remain in place. So nothing has changed. The Zambrano families still have no recourse to public funding. So unless they are able to, you know, like the Sane family, use their own initiative and their own resources, then they remain with a residency right until, well, we don't know. Will the government just turn around and say, well, you no longer have a residency right under European Union law, and you haven't been able to achieve a residency right under the European Union settlement scheme, so now you have to leave. What will then happen to the children? Perhaps they'll be taken into care. So I don't see any positive trend in this because the hostile environment continues. That continues to be government policy. So I see no trend to improving the situation for these families, and particularly for these children, Black children who are British citizens.
Guys, you can use the blue hand if you would like to raise it. So if we take it back to the European Union law, I was wondering whether, so the Brexit has happened. In a way, that ship has sailed, but there's a lot of work to do in other European countries, as we had discussed in the course over this semester. So there is an aspect here. We're focusing on the mother-child relation, which is one way to look at the care economy. But as we know, the care economy is much broader. And throughout the European Union, there are racial patterns that characterize the fact that the care economy tends to be more burdensome for certain groups of people, right? So, and there is some beginning attention in scholarship to the care economy in the European Union, including the possibility of spotting intersectionalities between other forms of discrimination and the status that comes from being stuck in the care economy without possibility of other opportunities in life. Do you see that as growing in the European Union? In other words, is there some silver lining here that might stem from the Zambrano Amendments and from the focus that your scholarship in particular is shedding, the light that is shedding on the fact that the care aspect involves so many people who should be given rights of residence and full rights of residence, not diminished, because they perform the essential function of care services.
Yeah, absolutely. So in the UK, there has been a campaign calling for key workers who may not have a regular status, residency status in the UK, to be given that regular status in recognition of their contribution to care during the COVID pandemic. And I think that there is more of a realization across other parts of the European Union. So other European countries didn't take the same response to the British government in relation to the Zambrano case. The Zambrano Amendments really are very specific to the United Kingdom. There were concerns expressed in other countries, but there wasn't as hostile a response. I think the European Union has realized that the care economy is crucial to enabling the European Union to grow and develop economically. So I think the European Commission has developed more policies in that area and has developed green and white papers in that area. Whether that will translate into more European Union law, and whether that will then translate into a different approach in the member states, I think remains to be seen. Because for the most part, especially when you're talking about an aging population across Europe, the care is given by non-Europeans. So the care is given by women from other parts of the world in Africa, Asia, and the Caribbean. And these are women whose status in these countries is generally not very secure. So their status is precarious, even though the care that they are providing is absolutely essential and is a care responsibility not willingly provided by the nationals in those countries. So there is most definitely a need for more protection for the Black and migrant women providing these essential care services. And I think that the European Commission is slowly realizing that, but I think it will take the member states a lot longer to actually get around to introducing legislation and perhaps even making the regularization of immigration status easier for these women. And to some extent, it benefits them to keep the women performing these functions in an irregular status, because it means that they can be paid less, for example. The more precarious their status, the less they can be choosy about how they work, where they work, and how long they work, and what jobs they take. So in a way, the difficult migration situation benefits the host states by ensuring that families that can afford it always have access to a cohort of cheap labor to look after their elders. And it's just another indication, I think, of how little care or how little importance is given to caring for elders across Europe.
Yeah, that definitely is my impression as well. So there's another question on demographics, but before we do that, I wanted to ask you, Professor Solanke, to talk about your experience of the two sides of the Atlantic. Because of your professional engagement, you have dealt with both scholarly communities, and I was once scholarly and activist communities, and I was wondering, how does it feel when you address the students in the United States with a particular history of handling race relations and the issue of discrimination? Does it feel different to address a crowd here versus a crowd in the United Kingdom?
That's interesting. So the difference between the United Kingdom and the United States is probably less than the difference between the United Kingdom and the United States on one hand and countries in Europe on the other. So what the United States and the United Kingdom share is an understanding of race and racism. In the United States, the conversation, even though it might be more vehement, the conversation is more present than in the United Kingdom. So talking about race in the United States, because race and racism and slavery is such a part of everyday life and is a part of basic education in the United States, you can't get away from it. Whereas in the United Kingdom, our history with colonialism and slavery is much more buried, much more hidden. So the conversation is less explicit, less everyday in the United Kingdom. That has changed to some extent since the Black Lives Matter movement of last summer. But for example, in schools, children won't learn about slavery or the colonial history of the United Kingdom in the same way that children in the United States will learn about slavery and the American Constitution. In countries in the European Union, I can say that now, in the European Union, it's very different again, because there is even less awareness of the colonial history in European countries, and there is even less awareness of the relationship with slavery in those European countries, and there is even less ability to talk about racism. So, for example, in a country like France, if the person who talks about racism is often the one who is seen as the racist. So the national sense of identity is such that any person who does identify a difference based on colour or religion is seen as the person who is going against the public norm. So it's very difficult to talk about racism and racial discrimination in that context. And the same is true, but for different reasons, in a country like Germany. So I've also lived in Germany and studied in Germany. And in Germany, the difficulty is that because race is so linked to the Holocaust, talking about, if I say anti-Black racism and slavery, is seen as is difficult because the subject is taboo. Across Europe, across the European Union, another big difference between the United Kingdom and the United States is the collection of race and ethnic data. So whereas it's very common for us to turn to either government official sources or even NGO sources and to be able to read about the different experiences of different groups because that data is collected, you won't find that data in the European Union. So even having the information, the evidence you need to develop policy to tackle race and discrimination is missing because the state refuses to collect that data. So the conversation between the United Kingdom and the United States is much more similar than the conversation across the European Union. So in a sense, there are times when I think it's nicer to be in the United States, because there I can talk more about race and discrimination. Whereas in the European Union, it's much more difficult, because beyond a very small group of informed anti-discrimination, anti-racist scholars, it's very, very difficult to talk about race in academia and in the general public.
So that's another casualty of Brexit, the possibility of, yeah. So we'll have to make sure that doesn't happen, that we lose the livelihood of that conversation. There's a question from Yo-Yo Huang, and the question is the difference between the Chen situations and the Zambrano situations. So we discussed the Chen case in class and the repercussions that it had in terms of legislation in the UK and in Ireland in particular. Chen versus Zambrano, different stories.
Yeah, very, very good question. So the Chen case, we thought that when the Chen case came out, it really couldn't get any better than, a parent being able to derive rights from their migrant child. So what did the member states do? They then started to change their citizenship rules. So it became harder to gain nationality just by being born in a country. So Zambrano, in the Chen case, if you remember, the mother, and I always forget which countries it was. I think she went from, did she go from Ireland to the United Kingdom?
So the baby was Irish because she was born in Northern Ireland.
Precisely, yeah. Right. So the baby was Irish, and then the family moved to the United Kingdom to cross the border. So there you had a migrant citizen, enabling the parent to enjoy derived rights. In the Zambrano case, as I said, the children were Belgian. They had Belgian nationality because they were born in Belgium, but they also lived in Belgium. And the parents were seeking to derive their rights from their children as Belgian citizens, despite using European Union law. So there was no migration in the Zambrano case. And that's the major difference between the Chen case and the Zambrano case. So whereas the Chen family had migrated from Ireland to the United Kingdom, the Zambrano family didn't migrate. So you had Belgian children claiming the rights of EU nationality in Belgium, the country of their birth.
So yes, so yeah, that definitely. So while the Chen case could be, so to speak, cured from the perspective of the British government by the change in Irish immigration laws, the Zambrano case was much more difficult, and therefore we had that wave of amendments after it.
Exactly, precisely.
So the another question, I think it has to do with demographics, the need for immigrant labor. How much, the question is phrased in the sense of how much of that can be absorbed by Europe, but we can also talk in general about the demographic issue of migration in the European Union. There is an economic reason for the movement of migrants from other parts of the world to the EU and the United Kingdom, but there is also a demographic issue. Are these things adequately discussed? The need and the capacity to absorb more immigration forces?
So I don't think that there is a general understanding of the desperate need for migration because European societies are aging. I think that is a very common conversation amongst demographers, amongst statisticians, amongst public policy specialists. But in general public terms, I don't think there is a strong awareness of the need to import youth, essentially, and to import families that have children. Because the birth rate across European Union countries is declining and has been declining for at least the last decade. And that trend is unlikely to reverse, although I read somewhere recently that during the pandemic, there has been a strange increase in childbirth in some countries, not in all, but in some countries. Yeah. In other countries, the trend has been the reverse, because families are too scared to have children because they don't know what the future will hold. So I'm not sure where Britain thinks it's going to secure or replace the European Union migrant workers. The only place, obviously, is from beyond the European Union. And that in itself is going to it's quite ironic in a way, because if you think about the anti-immigrant Brexit, anti-immigrant sentiment that was driving Brexit, it was mainly to do with brown-skinned people. Now, without the European Union migration, the only place that the United Kingdom can turn to get the kind of workers to do the work that is necessary is the global south. So ultimately, the United Kingdom is going to be forced to rely upon those brown-skinned workers that it used as a scapegoat to secure the Brexit result. Go figure.
So interesting. So I don't see blue hands, so I'm going to take the last question. Actually, it's not a question, it's an invitation. It's an invitation from one of our attendees to visit the Center for Anti-Racism that was recently established at Boston University.
Great.
And so we'll discuss the opportunity of your visit there later on.
I would be very happy to. Thank you for the invitation.
So this was wonderful. I would, why don't we all unmute ourselves and just clap, because I think we can do that. And we can. This was wonderful. Thank you so much, Professor Solanke. So we'll continue this offline, and there will be other opportunities to engage with such issues. This was tremendously helpful to me, in particular as a teacher of EU law and as somebody who's pretty worried about the development of a more inclusive society in Europe in general. So we look forward to having you again with us, and all the best for your research and for everything.
So enjoy the rest of your seminar, and I look forward to continuing this conversation at another opportunity with you.